When complaints are lodged against criminal justice personnel, they are generally required by policy to cooperate, and in fact, failure for a law enforcement officer to cooperate may put his or her job at risk. Having said this, individuals who work in law enforcement still have constitutional rights which are possessed by all citizens, and they do not forfeit their rights merely because of their professional responsibilities. Over the years, courts have tried to balance the rights of law enforcement personnel against management's need to internally investigate complaints against its employees. There is still quite a bit of uncertainty in this area. For example, suppose a police officer is involved in the use of deadly force. Let us suppose that the officer kills an individual, and just for the sake of discussion, suppose the officer circumvented official policy. Does the officer have a right to counsel before providing his superiors with an official statement of the event? After all, the officer's statement will be a matter of record and could even be used against him in a criminal proceeding. To answer this question, this may vary from state to state and from department to department, as the U.S. Supreme Court has never actually ruled on this issue. This presentation will explore topics which are related to the procedural rights of criminal justice personnel during the disciplinary process. In Garrity v. New Jersey, the court examined an officer's Fifth Amendment right against compulsory self-incrimination in a law enforcement disciplinary setting. In the Garrity case, the court ruled that if an officer is forced to answer questions in an employment proceeding, the answers to these questions cannot later be used to convict the employee in a subsequent criminal prosecution. 1 year later, in 1968, the court ruled in a separate case, Gardner v. Broderick, that a criminal justice employee cannot be forced by his or her employer to sign a waiver of immunity which permits statements from an administrative investigation to be used in a criminal case. Under the Gardner ruling, if an employee can only be disciplined for refusing to answer questions during an administrative investigation if he or she is granted immunity. Also, the Gardner case limited the scope of the type of questions that administrators can ask an employee during an internal investigation. The questions must have a direct bearing upon an employee's job. During an official investigation, an employer only has a right to ask an employee about off-duty conduct when there is significantly related to an officer's on-the-job performance. The employer must be careful not to violate an employee's privacy by asking unrelated questions. Otherwise, this may give the employee more opportunities to overturn an adverse disciplinary action, even if it's warranted. Under the Garrity and Gardner rulings, it is imperative that a manager of criminal justice personnel advise an employee that any answers obtained will not be used in criminal proceedings. So long as this is done, an employee may be disciplined for insubordination if he or she refuses to answer questions during an administrative investigation. But again, the employee must be told that the statements will be privileged and not used in a future criminal proceeding against the employee. Also, the employee does not have the right to consult with an attorney prior to giving a statement. The reason for this is that at this point it is an administrative matter, not a criminal one. However, under the Weingarten rule, which shall be discussed later, the employee may be permitted to meet with a union representative before any questioning begins. Interestingly, a criminal justice employee makes a statement If they make a statement during an internal investigation, he or she is only given immunity from prosecution if the employee is ordered to answer a question. So what I'm getting at is if an employee voluntarily makes a statement, this may be used in a subsequent criminal proceeding against the employee. During an administrative investigation, it is only when an employee is ordered, either verbally or in writing, to answer a question that statements will be given immunity in subsequent criminal proceedings. So a criminal justice administrator cannot have his cake and eat it too. It would be unconstitutional to require an employee to answer a question during an internal investigation or be discharged only to later use this answer, which was compelled, as material to be used in criminal proceedings against the employee. Garrity rights are triggered whenever employees face a substantial economic penalty for not answering questions during internal investigations. It is important to note that Garrity rights do not protect an employee's statements from civil lawsuits. This means that even if an employee is compelled by an employer to answer questions during administrative proceeding, the answers can be used in later civil proceedings against the employee. The Fifth Amendment does not provide protection in this area. Also, any statements which are obtained can be used in the criminal prosecutions of persons other than the employee who is being questioned. So long as the employee himself is not being prosecuted as a result of his or her statements in an internal investigation, there is no violation of the Fifth Amendment's right against self-incrimination. It is important to note that there are a few states, such as California, which actually provide employees with Garrity protections even in civil proceedings. As alluded to earlier, in law enforcement agencies which recognize collective bargaining rights by organized labor, employees are entitled to have a union representative available during a disciplinary interview. This is known as the Weingarten Rule, and generally employees are entitled to representation in any situation where they believe they are subject to disciplinary action. Also, the employee must request representation, as it is not automatic. It should be noted that the Weingarten Rule is not automatically binding on all law enforcement agencies. Having said this, virtually all state collective bargaining rules contain provisions which are very similar to the Weingarten Rule. An employee cannot discriminate against an employee who exercises his or her Weingarten rights. The Fifth Amendment Due Process Clause not only protects a criminal justice employee's statements during administrative hearings, in some cases it may also protect employees from arbitrary employment actions, especially in situations where an employee has a property interest. A property interest is created through a continuing expectation of employment and may be established through collective bargaining agreements, personnel manuals, contracts, as well as civil service rules. Also, a state or federal statute can impose standards that a law enforcement employer must meet before imposing discipline. Even comments or promises from a criminal justice employer may be sufficient to establish a property right. While employees with property rights can certainly be disciplined, they are nevertheless protected against arbitrary discipline. Also, probationary employees typically do not have property rights and can be fired for any reason so long as it is not an unlawful one. And if a criminal justice employee gains permanent status, he or she cannot be converted to a probationary status, as this deprives the employee of due process. If a criminal justice employee has a property interest, he or she is entitled to procedural due process before being involuntarily retired for a disability or placed on unpaid leave for a medical or psychological reason. Also, if a manager of criminal justice personnel wishes to discharge an employee or reduce an employee's pay grade, he or she must provide the employee with due process. This essentially means that the employee will be notified of the disciplinary charges in advance and have an opportunity to make his or her case. Generally speaking, due process is not required in situations involving a reprimand. So, for example, if the lieutenant of correctional officers wishes to reprimand her sergeant in writing, this is generally permissible and due process is not required so long as the reprimand does not pose an undue economic hardship. Also, if a criminal justice employee is being reclassified to another job, a due process hearing is not required so long as the reclassification is being done for non-disciplinary reasons. A manager of criminal justice personnel is also free to give a subordinate an unfavorable performance evaluation without going through the due process procedure. As you probably know, the exclusionary rule prohibits prosecutors from introducing illegally obtained evidence during a criminal trial. But is there an exclusionary rule in the disciplinary proceedings of criminal justice employees? Generally speaking, the answer is no. The majority of courts have refused to apply the exclusionary rule to bar illegally seized evidence in a disciplinary proceeding. So, for example, let us suppose that a criminal justice employee is suspected of selling stolen property. Suppose an internal affairs investigator improperly searches this employee's backyard and finds what appears to be a stolen flat-screen television set. Even though this search would be inadmissible in a criminal court, the evidence could still be admissible in an employee disciplinary proceeding. The fact is that there is a lower standard of evidence in an administrative proceeding. While the exclusionary rule generally does not apply during internal disciplinary proceedings, administrators can go out of their way to entrap an employee in order to prove their disciplinary case. It can be shown if it can be shown that a governmental agency in any way orchestrates a scenario that entices an employee to violate departmental rules, a court or civil service board may very well overturn any disciplinary action that is imposed. Administrators during internal investigations must not exceed the bounds of legal propriety. There must be a sense of decency and fundamental fairness. It is important to remember that criminal justice employees, like the citizens they serve, have certain rights. Managers of criminal justice personnel have the right and even the obligation to discipline employees who do not follow policies and procedures. Still, they must balance the needs of the organization against the personal rights and liberties of the employee. It is highly recommended that administrators of criminal justice agencies familiarize themselves with the procedural rights of their employees during the disciplinary process. If upper echelon administrators respect the procedural rights of their employees, this will safeguard civil liberties and help to ensure that any disciplinary action which is imposed will not be overturned later down the line.